Yeah.
Good morning, everyone. Thank you so much for joining us. This morning, we're very excited to have our friends from Godfrey Kahn here with us to unravel the complexities and help you prepare to comply with California's new privacy law, the California Consumer Privacy Act, or CCPA, as it's most commonly known. This is an especially important and timely topic, with CCPA going into effect on January 1st of 2020. And since the new year will be here before we know it, now is the time for organizations to start preparing. So we're glad you're here and are taking the time to learn more about the legal and digital implications of this new law. Before we dive into the main presentation, I want to share a couple of housekeeping items with you. Today's webinar will run about 1 hour with 40 minutes or so for the main presentation, followed by a Q&A. As questions come up while you're listening, please go ahead and submit them in the chat area, and we'll answer as many as we can during the Q&A session. Also, an email with a link to a recording of today's webinar and a PDF of the slides will be sent out in the next day or two, so keep an eye out on your inbox. The PDF will also contain a resources and annex section that contains links to reference sources and more details, including definitions on the law and specific disclosures. Okay, for those of you who are new to our webinars who aren't familiar with Northwoods, I want to very quickly introduce ourselves. We are a digital strategy, digital marketing, and software development company located in Milwaukee, Wisconsin. We've been helping companies grow their online presence since 1997 and have worked with more than 750 clients of all sizes across a variety of industry over the years, from manufacturing and healthcare to nonprofits and professional service firms, and many, many more. You can learn more about us at northwoodsoft.com. But enough about us. Let's go ahead and turn our focus to CCPA. I'd like to introduce you to our presenters today, starting with myself. My name is Jim Brophy. I'm Group Director of Digital here at Northwoods, overseeing our digital strategy and digital marketing teams and services. I will be moderating the webinar this morning. Also with me from Northwoods is Brett Smoot. Brett is a digital marketing coordinator at Northwoods and has managed digital marketing projects since 2012. Brett focuses on helping clients achieve their goals through deep data analysis to discover new ways to optimize performance. He's also heavily focused on digital risk reduction and is one of Northwoods' go-to team members for online compliance with CCPA and other privacy laws. Sarah Sargent is an attorney with Godfrey Kahn and is a member of Godfrey Kahn's Data Privacy and Cybersecurity Practice and Technology and Digital Business Practice groups. She holds both Certified Information and Privacy Professional U.S. certification, known as CIPP US, as well as a CIPP-E certification from the International Association of Privacy Professionals, allowing Sarah to draw from both domestic and international best practices when it comes to questions of data privacy. And last but not least is Andy Schlitt, also an attorney with Godfrey Kahn. Andy is chair of Godfrey's Technology and Digital Business Practice, as well as a shareholder in both that practice and the Data Privacy and Cybersecurity and Corporate Legal Practice groups. Andy helps to demystify IT compliance for clients with a focus on data breach response, privacy and cybersecurity programs, vendor management, cyber insurance, and IT dispute resolution. So I'm going to hand things over to Andy here in a minute to start our deep dive into CCPA. But before I do, we'd like to start off with a quick poll. If you could please let us know what department you work in at your organization, that will be really helpful for our presenters. So I'm going to give you a few seconds here to respond while I hand the mic over to Andy. Okay, thank you very much. And now here's Andy.
Great. Thank you for completing the poll. And Jim, thank you for that kind introduction. Sarah and I are both with Godfrey Kahn, and we're so thankful for the chance to pair with Northwoods on this presentation and talk about not only the legal requirements of CCPA, but also the technology solutions that will help companies meet those requirements. So our firm is a full service firm. We're headquartered in Milwaukee with over 170 attorneys, and we cover all areas of law. But of most interest to Sarah and I is the data privacy and cybersecurity practice, where we focus on guiding clients through implementation of privacy programs and implementation of cybersecurity programs to help clients reach compliance with legal requirements applicable to their companies. And so in that regard, we also advise clients in responding to data breaches. We work in drafting policies and procedures with our clients. And we also help clients negotiate various vendor agreements. But of course, lately we've been fielding with clients many questions regarding CCPA. And so today we'll get a good start on the steps towards CCPA compliance, but just a quick note that this will be just that, a good start. And based on the information that you received today, you'll want to circle back in with your in-house legal department, IT staff, or your outside vendors to help you put the final touches on a CCPA plan. But we'll certainly get you started and headed in the right direction with a basic first question, and that is, what is the California Consumer Act? And it's the first of many questions that we'll attempt to address today. Other follow-up questions include things like, I'm not in California, how would this law apply to me? Or I'm not in the consumer business, I'm a B2B company, so this law wouldn't apply to me, right? Or questions like, I'm not subject to GDPR, so I wouldn't be subject to this privacy law either, would I? And then we'll also move more so into substantive questions, such as, if I receive a request to delete all of my information, do I really have to delete it? Or if I receive a request, or do I need to receive opt-in consent in order to send marketing materials under CCPA? So there's no shortage of interesting questions, but Sarah, why don't we dive into this first fundamental question, and that is, what is the California Consumer Privacy Act?
Yeah, thanks, Andy, and thanks everyone for joining us this morning or afternoon, depending on where you are in the world. So what is the CCPA? The CCPA is a California law that was passed rather quickly back in 2018, and it comes into effect January 1, 2020, with the Attorney General of California is going to be releasing some guidance hopefully this spring to finalize that guidance, but maybe draft guidance this fall, we hope, with more clarifications about some pieces of the law. There were recent amendments that were cleared through the California legislature last week, so we will talk about those a little bit further into the presentation, and those are headed to the governor's desk for signing. So there will not be any further amendments besides those that were passed for this session. However, further down the line, I suspect there will be much more lobbying and amendments that will go on as we get closer and past the effective date. So in general, the California law is a privacy law that generally applies to all companies, and then there's certain exemptions of information. And as Jim noted earlier, because of our timing here, we did include an annex that has some detailed information. So if you're looking for text of the law or resources, please go to that. So heading into those amendments that were recently passed by California. So first off is AB 1146. AB 1146 carved out vehicle information in some instances and vehicle owner information from the law. It also carves out until January 1, 2021, information that's business to business type information and employee type information. So that's not that the information is carved out from all aspects of CCPA, but for certain types of information, there's going to be exceptions for employment and for business to business information until 2021 when the amendment expires. So things like having an employee have a access request or a deletion request won't be something that companies will have to deal with until later in the law. Also, there's AB 874, which changes the definition of personal information for some clarity. It's not a huge change to the law, but they are adding in that information is reasonably capable of being associated with an individual. So we'll talk a little bit further about the definition later on, but for those of you that have already been looking at CCPA, I wanted to flag that for you. Finally, there's AB 1564, which was a clarification on different types of methods that a consumer or that a company has to set up how a consumer can request certain information from a company. So other things to keep in mind while we are talking about this, there is a trend with these privacy laws that they are going to be more opt-in consent, and there's going to be a move towards companies deferring to opt-in consent. CCPA does not require opt-in consent for things like cookies. However, there is quite a big trend now for companies to start adopting those cookie banners. So we'll talk about that a little bit further in the slide, but I wanted to get that introduced for you. Also, there is going to be some things that we talk about related to GDPR, which is the European Union's General Data Protection Regulation. And so that could impact companies that have a little bit of a more global presence, and we just wanted to key that up. The main thing to keep in mind is that moving forward, we really are going to see a big push for transparency. Consumers are going to expect transparency, and the laws are going to expect transparency in what you're doing with information. So why should I care? The big, big important question, why should we care about California? Well, as California goes, so goes the nation. And what we're seeing is that more and more states are looking at privacy laws. And while a number of laws, a number of states, such as New York and Texas and Washington, introduced privacy legislation that didn't quite get passed, they are expected to come in the next round. So it is a good time to start taking a good look at your privacy program and start asking these questions. Also, did want to note that Nevada recently passed a law that will go into effect next month in October, and that one is similar to CCPA, but a little bit more narrow in applicability.
And so diving now, Sarah, into some of the key terms and definitions of the law. One of the main questions our participants might have is what type of data falls within the purview of CCPA? And this is answered by looking at the definition of personal information. So CCPA defines personal information very broadly as essentially any information that can be associated with a consumer or a household, whether directly or indirectly. In Wisconsin, by comparison, though we don't have a CCPA-like law yet, we do have a data breach statute, which defines personal information very narrowly. And we're accustomed to viewing that definition in terms of a name, such as last name, first name or first initial, with a social security number or a financial account number. And that combination, at least for us in Wisconsin, has traditionally been what we have viewed as personal information. But CCPA is so much broader than that. And personal information includes things such as biometrics, geolocation data, internet activity and browsing history, and even inferences that can be drawn from those to create a profile of an individual. Another definition that we want to focus in on is the definition of sale, and what constitutes a sale of that personal information. And this is important because CCPA regulates the sale of personal information and allows individuals to opt out of that sale. The term sell is also very, very broad, and it's not what we would typically think it to mean. It's not just a transfer in exchange for money. but it's also a transfer for anything of value. And so an example of that individuals studying the law have considered is whether or not, in a SaaS context, for example, if a company enters into an agreement with a SaaS vendor and gives that vendor access to personal information to use and to improve the service over time, whether that improved service delivered back to the customer is actually consideration that would trigger a sale under CCPA. So this is one of the trickier elements of the law. And there's discerning that needs to occur as to whether your business is engaging in the sale of personal information as defined under CCPA. Another definitional question that businesses will have is whether their business is actually subject to the law. And this gets into the definition of business. And there's a three-part equation or inquiry to undertake in this regard. And the first is to ask the question, are you in fact a business? And so CCPA defines this as we would expect it to. And it means a sole proprietor, partnership, LLC, corporation, or other legal entity that is in the business, in a for-profit business. The second element of the inquiry is whether you're actually doing business in California. And this goes well beyond just whether you have a physical presence in the state. It looks into whether you're actually selling goods or services in the state, whether you have employees in the state or contractors, important contractors, whether you have customers, whether you pay taxes in the state. And so we think in counseling clients that if you are selling services in any form in California, you are likely to be considered doing business in that state. And then the third element of this equation is whether or not your company meets one of three numerical thresholds. The first threshold is whether your company has annual gross revenue in excess of $25 million. The second threshold, and these I should point out are an or, not an and. So if you meet one of these, then it will subject you to CCPA. The second threshold is whether you collect personal information of 50,000 or more consumers, households, or devices. And the third threshold is whether the sale of personal information accounts for 50% or more of your annual revenue. So the bottom line is that if you are a business and you're doing business in California and you meet one of these three numerical thresholds, you will be subject to CCPA. Sarah, and as a result, that means you'll be required to meet certain requirements under the Act.
Yeah, so diving into what does CCPA actually require you to have? So as Andy was already talking about, CCPA puts some guidance and obligations on companies that sell personal information. And so when you take a look at whether you are selling personal information, you look at whether you are doing that to third parties rather than service providers, which service providers, if you have certain contractual language in place, that's not going to constitute a sale as long as they aren't using that information for anything other than providing you services. Also, individuals are able to opt out of that sale. So that's going to require a mechanism for that to happen, which is a do not sell link on your website. And then you also have to respect that do not sell request if it comes in and you do indeed sell information. So you must allow people to opt out of that sale if in fact your company is selling information. Also, CCPA requires a number of notices, and we have a detailed slide in the annex that goes into the specific types of information you have to include in your notice. But it does include things like what information are you collecting, who are you sharing it with, what are you using that information for? And so we're going to see, similar to as we did with GDPR, a number of updates to privacy notices or privacy policies that sit on websites. And companies are required legally in the US to comply with those policies, or else you can get in trouble with the Federal Trade Commission. So it's very important that your notices are transparent, and you follow them accurately. So CCPA also gives data subjects or individuals whose information you collect certain rights outside of the opt-out of the sale of information. So people can request that they get a copy of their information from you. They can request that you take that information and provide it to them in a format where they can transfer it to another company. And they can also request that you delete their information. And this is the one that I see the most anxiety over, is this request to delete. And just so you know, these are not rights that are blanket rights without limitations and without exceptions. There are some limitations to data subject requests, and those would be that, one, a company has to verify who the individual is. We don't want bad guys and people with bad intentions requesting other people's information so they can run out and collect identity, do identity theft, or anything nefarious. So there is a obligation of how you verify that individual. And a lot of companies now are struggling with, well, how do I do that? So we're hoping to get a little bit more guidance from the California AG on how that works, but we will see if they put any verification requirements in. There are also exceptions to the right to deletion, such as for legal obligations for a company, or if you need to do certain things for security on your website. So there are a number of exceptions to that deletion request.
One of the other requirements is in the area of vendor management, and CCPA requires that companies pass through to vendors certain compliance obligations. And those obligations include, for example, a requirement that the vendor protect the personal information that you're sharing with them. Another obligation is that the vendor assist you in compliance with CCPA. For example, if a data subject makes a request for you to delete their information and it's your third-party vendor that holds that information, you'll want in your contract an obligation that that vendor will comply with the request to delete, even if they didn't receive it directly, if it came indirectly through you. You'll also want language confirming that the vendor will use the personal information only to provide the service and for no other purposes beyond that. An additional requirement under CCPA is training. CCPA requires that a company adequately train those employees who will handle data subject inquiries. And that training should be completed by January 1st of this coming year, the effective date of the Act. In order to comply with data subject access requests, companies will need to put in place internal procedures for fielding and then responding to and documenting how those requests were responded to. And this is where the training element becomes important. In that you'll want employees responding in a consistent manner to these requests.
So another big why we care is the penalties. So what if a company doesn't comply with CCPA and they're required to? How could they get in trouble? And one way is through the California Attorney General. So if a company fails to, say, have the proper notice on their website, or they sell someone's information who's opted out, then the Attorney General can bring an action against the company. The company does have 30 days to fix that error, which is great on the company side. So you have 30 days to fix that. However, if you do not fix it, there is a civil penalty that comes into place for each violation. So that's $2,500 for, if you think about it, each individual who you sold their information when they opted out. Or there is a maximum penalty for intentional violations of $7,000. So there are some fines associated that you should keep an eye on. Also, there is a private right of action in the law, which means that if you do something wrong, you can get sued. That's what private action means. And so when the private action that you can have under CCPA is related only to data breaches. So if you have a data breach and it's because the company failed to have reasonable data security practices, then your company can get sued by a consumer whose information you lost. And that is going to be damages between $100 to $750 per consumer per each time that you lost their information. Or actual damages, whichever one is greater. So because there's statutory damages here, that means that you are going to have plaintiffs' attorneys who are very eager to leverage CCPA to be able to get those statutory damages. Also, a court can honor injunctive relief as well. So dates to remember. As I mentioned, the effective date is January 1, 2020. The California AG enforcement date is coming up on July 1, 2020, or 6 months after the final AG regulations. We suspect that the July 1, 2020 date will come first. And also, CCPA has a 1-year look-back date. So a company is required to update their privacy policy or notice once every 12 months. And when you do that, you have to look back on how the company handled information for the past previous 12 months. So because of that, it means that as of January 1, 2019, hopefully you knew what your company was doing with information. And if you didn't, that's okay. You're in the same boat as a lot of individuals, but we do want to raise that look back period. So one question we often get is, well, we already did GDPR, so CCPA, we're good, right? Well, kind of. So what's the difference between GDPR and CCPA? Well, one of the big differences is how we define personal information. What's very interesting is because CCPA ties the definition of personal information to a household or a device, it means that actually personal information is broader under GDPR than CCPA. So you actually have instances where maybe GDPR doesn't apply, but CCPA would apply, such as, for example, telematics information about a device or a vehicle or a household. Also, CCPA has training provisions that are very specific, and there are things in your privacy policy that CCPA requires that GDPR does not. Finally, there is also some additional things that you have to put on your website, such as that do not sell link, and you have to have at least 2 methods for individuals to call in or email in and request that you fulfill their access requests. So, what are your next steps? So what we're seeing a lot of companies do right now is figure out where their data is. But before you go on and do a big old CCPA compliance, it's first you should understand, do you fall within the law? That's step number 1. So are you caught by the law? If you're caught by the law, data mapping and data inventory is really, really key, really crucial. So figuring out what data do we collect, where is that data, who do we share it with, where does it go? That is a huge, big question that companies need to tackle. Some companies are doing that manually through inventories, questionnaires. Some companies are doing that through tools that you can use to leverage those things. Some reminders here. This isn't only marketing and sales data. This is going to be your employee data. And while it's not employee data that falls under particular parts of the law subject to that new amendment, you will eventually have to do employee data. So you might think about whether it's important to do it now versus later. Also, a number of companies are going through the process of building in those compliance policies for handling requests and for doing different, making sure that their privacy notice is up to date. And so you have to make sure, so when a access request comes in, who is it going to, who's responsible for responding to it, and in a timely manner. Also, you need to make sure that you're training employees, and there are some audit and test procedures in place, and really doing that update to your privacy policy, and updating your contracts as well. Some of them, as we get closer to the law in place, if you're just starting with CCPA, really start with that data mapping, data inventory questions. If you are moving towards getting ready for compliance, then really I see a lot of people focusing on the publicly facing compliance pieces, that privacy notice, that do not sell link. So really focusing in on those aspects of it. And with that, I'm going to turn it over to our friends at Northwoods to talk a little bit more about some solutions to these requirements and problems that CCPA raises.
Thanks so much, Sarah and Andy. Appreciate it. All right, so as you've seen, if you need to comply with CCPA, you're going to need to identify and implement a solution to ensure compliance. And there are several solutions out there to consider from a technical perspective. We're going to spend a few minutes now walking you through a solution at Northwoods that we have vetted and have implemented on our own Northwoods website called Cookie Pro from OneTrust. So Brett is going to kind of walk you through some of the aspects of this solution. And again, if you have any questions about Sarah and Andy's portion or what Brett is about to show you, please enter your question into the chat area. We've already got a few questions coming in. So Brett?
Thanks, Jim. Just going to quick pull up the website here. So we're looking at the Northwoods website here. You can see across the top we have our cookie consent banner. One of the things that everyone should be looking at is showing your customers you care about privacy and giving them the choice on how to manage what information they're giving you. This also helps you control what information you house and allows you to see where you're collecting those points of data and the different points of management. We're using Cookie Pro, like Jim said here, and one of the features of it is being able to provide a customized experience to your users to allow them to go ahead and manage what information they're providing you, and also provides a pretty nice audit tool to let you know what information you're collecting from users as far as scanning for cookies and things like that. You can see we've customized our banner here and our preference center to kind of let the customer know what information we're collecting. One of the nice things about Cookie Pro is the customizability. We've worked with our team here to make sure we've got it looking like our brand and broken the cookies down into different sections, letting the users know what type of cookies we're collecting and how they are being used. One of the big things of GDPR was this, but also as other privacy laws come in, being able to work with that and already have a strong basis for collecting that type of information and knowing what's going on with your site. These are quickly becoming staples across all websites. And if you have any questions on setting something like this up, we'd be more than happy to talk to you here at Northwoods. So one of the other parts that comes with Cookie Pro is the data subject response portal. And this is a big part of CCPA, is giving your customers a way to inform you and say, hey, don't sell my private information. You might have seen forms like this for GDPR, but they're going to be very key when it comes to CCPA and having customers inform you that they'd like to take action on the rights the CCPA has granted them. So you can see here that we have a demo form set up that allows a user to come and identify what type of customer or employee they are to let you know what's going on. Like Sarah said, the employee piece has been deferred a little bit under some circumstances. We've built this demo form out here to show you the different things. So maybe I'm a customer coming in here and I want to assert I just want to have all my data deleted. They could choose multiple options if they would like, but we'll set up for a data deletion here. I could fill this form out. And what would happen then is I would get an email as the user saying, please verify who you are, is kind of that first step process to make sure this is a real request and not a spam one. But also it's going to notify the team that is managing this via a portal and email notifications that they've had requests come in. So now we're looking at the portal that comes in. And one of the nice pieces of this is the customizability of this. We can work with you to set up different steps, work with your legal team to make sure the language and step process that we talked about earlier, making sure there's always a consistent experience, as Sarah said. And one of the pieces here is There's a different way to communicate with internal teams, making sure that the right information is getting communicated internally and the step process is being covered. But you can also communicate with the person making the request. And one of the things the legal team might cringe a little bit and say, well, we don't want them just writing whatever they think of off the top of their head. There are pre-built responses that can be managed here. As you can see, we've set up a Northwoods test, but there are also ones provided by Cookie Pro as templates for your team to build off of for CCPA. We also have the GDPR ones here. There's the right for deletion under here, and our user could manage which response they'll send, be able to customize the customer's name and things like that. Having a portal like this to be able to manage those requests is going to be very key to make sure that you're providing a consistent response and all of the steps are being hit. So we could walk through each of these steps as the employee managing this. And part of the training that was talked about earlier on would be how to use a tool like this and what does that process look like and what should be done at each step. Each step can have different custom text being put there, and our tool just crashed. But luckily, we are at the end of this demo piece. So I'm going to turn it over to our Q&A team here to go ahead and start diving in on the Q&A piece.
Thanks, Brett. That's usually the way things happen like this, right? You're in a live demo and all of a sudden something goes awry, but I think you got through most of it, so thank you very much. And again, any questions about Cookie Pro or any other technology solutions, we at Northwoods here would be happy to answer those questions for you. So we do have some questions that have come in, and so I'm going to pose this to the group. So if it applies to your area of expertise, just kind of hop right in here and provide an answer for us as best you can. So the first question is, can you tell me whether the annual gross revenue threshold applies only to our sales in California or total company sales internationally?
Sure, and this is Andy. That's a great question, and one that we've had to take a look at with a number of clients. Our sense, and in reading other commentary on this, is that the gross annual sales threshold applies to sales globally across your enterprise, and not just to sales within California. It's possible that the Attorney General in their guidance will clarify that further, but we think the intent of the California legislature was to impose restrictions on larger companies who have the wherewithal, given their gross revenue, size of the organization, to comply with these requirements, regardless of whether all or just some of their revenue is generated from California. So we've been advising clients that if any of your revenue is derived from California and collectively across the organization, your gross sales exceed $25 million, that you should be planning to comply with CCPA.
Great, thanks, Andy. Here's a couple of questions that are somewhat related. I'll read them both here because I think we can answer this with one response. But the first one is it still correct that as currently written, CCPA will not apply to nonprofit companies? And the second question is, we are a nonprofit and do not sell any products or services online. We mainly deal with people locally in Wisconsin, but potentially could have people in California sign up for newsletters or make a donation. Should we be concerned about CCPA?
So no, the CCPA does not apply to not-for-profit organizations. So if you are operating as a formal nonprofit, then CCPA will not be applying to you. Rather, it's going to be applying to those for-profit businesses, a corporation, an LLC, a sole proprietor, those types of organizations.
Sarah, I would also add to that, good answer, is that there may not be a legal requirement to comply, but just in terms of customer relationships and providing the type of comfort that visitors to your site might expect because they see these types of protections when they visit other sites. Though 100% compliance with CCPA would not be required in that case, you might look at some of the low-hanging fruit here. For example, updating a privacy policy that would incorporate elements of this that you think are easy enough for you to comply with. You might also look at, for example, the cookie banner concept. Not that it's legally required in this circumstance for you, but because individuals you interact with simply are growing to expect that level of protection, when visiting online locations. So again, not legally required, but we do have some clients who are just voluntarily starting to move in this direction over time in recognition of the fact that privacy law in the US is moving in this direction. And so, whereas the California law may not require your compliance today, a law in Washington or New York or Wisconsin may require it tomorrow. And so it's good nonetheless to be thinking about movement toward compliance in this direction.
Great, awesome. I have a question that I'm definitely going to let my friends at Godfrey and Kahn respond to. The Investment Company Institute has taken the position that GLB completely preempts the CCPA for mutual fund companies, both with respect to prospective investors and existing investors. What are your thoughts on that?
So there are carve outs for certain types of personal information under CCPA, and that includes GLBA or Graham-Leach-Bliley, which is a law that regulates financial services companies. So for GLBA, there is an exception for personal information that is covered by GLBA. There's also an exception for information that is covered by HIPAA, which is a healthcare law that governs the privacy of our healthcare information. So that information is exempt under the law. However, that does not mean that an entity that is subject to Graham-Leach-Bliley or GLBA is exempt from the law. So if, for example, a company has information that is related to marketing or sales that is not covered by Graham-Leach-Bliley, then that information would be subject to CCPA. So that is one distinction that a lot of financial services companies are going through right now. What information applies to those, what information applies under GLBA and what information falls under CCPA, and where is that exemption? Really documenting that exemption and making sure that you have that internal record in place on what you think is exempt from CCPA.
I am really glad you guys are here. All right. Another question. Did I hear correctly that CCPA does not apply to B2B until 1/1/21 due to the amendments?
Yes, there is certain types of business to business or B2B information that is going to be exempt due to the amendment until January 1, 2021. However, that is not that the whole entire law is exempt, it's just certain portions of the law. So for example, those deletion requests and access right requests, that will not apply. However, the notice requirements will comply. So you do need to still be doing that data mapping, that data inventory of what information do you collect and disclosing it. So it's not a wholesale exemption, rather it is certain types of business to business information, and it is only for certain parts of the law. So there will still be business to business information that potentially is coming unless another amendment down the way is going.
Okay, so it sounds like there was a partial follow-up to that initial question. I think you just addressed most of that, but let me read it just to make sure. Will there be different rules for B2B, or is that still being determined, especially data deletion requests from contacts that may have been involved with a sale or startup of technical equipment that may fail or could cause bodily harm?
Yes, so I do think that we will see further lobbying around what rules are going to apply to business information. However, because we just have more of a deferment till now, it's not really that I think the business information will fall completely out of the law. It might have different rules that apply, but that's going to be something that, we shall see in the future. So I think to be determined on all of the answers to those questions, but I think for now, if you are specifically looking at what business-to-business information is exempt, I recommend that you do a deep dive of that with either your in-house counsel or outside counsel, or with your privacy compliance officer.
And just a quick follow on, the latter part of that question is really intriguing, and that has to do with deletion requests regarding information that's pertinent to a product safety type claim or a bodily injury claim. And I think that's of interest to all companies, even outside of the B2B context. And this question of whether an individual asks you to delete their personal information that you think is important to keep because it's pertinent to a potential product safety or bodily injury claim, falls, I think, within one of the exceptions to the deletion request. And that is that you'd claim the exemption to keep that information because there are legal requirements related to it. In fact, there might even be, for example, a litigation hold related to it, or you feel you need to archive it in order to defend yourself in the event of potential litigation in the future. So I wanted to point out as to the second part of that question and re-highlight, Sarah, I think a good point you made earlier, that there are some exceptions to the deletion requests, and that companies covered by CCPA do not automatically have to delete consumer information when requested to do so. There's an analysis that you want to undertake as to whether there's an exception that would allow you to keep that information.
Great. I have one more here. Is there any guidance with respects to inferences made about consumers through the use of advanced analytics?
So inferences about consumers are considered personal information under the law. So if you're making an inference about someone and can tie it back to a certain individual, that would be considered personal information and fall under the scope of CCPA. However, kind of where that line is and how that fits in with protecting your proprietary information and analytics process, that is kind of something that companies are working through right now. So we don't have specific guidance from the AG or even draft guidance yet about how to deal with inferences. However, it is clear that that will be personal information that falls underneath the law.
And to add a little more context to that, to give you a sense of that definition of personal information, I'm just going to read the language here from the law. And it says that personal information includes inferences drawn from any information that has been collected or that otherwise fits within the definition of personal information. It goes on to say inferences that are drawn for the purpose of creating a profile about a consumer that reflects the consumer's preferences, characteristics, psychological trends, predispositions, behavior, attitudes, intelligence, abilities, or aptitude. And so when Sarah says we're all looking for a little more guidance as to how to handle inferences, I think that's accurate given how broad and encompassing that definition is.
Great. I do have another question here. How easy is Cookie Pro to implement? I'll take that one. Of course, the answer here is depends. Depends on your platform, your technology stack, what you're trying to do with it in terms of the full suite, the level of licensing that you purchase. But suffice it to say, Northwoods can come in and take a look at your current technology landscape and certainly make recommendations based on what we see, what the law is going to entail, any final amendments that need to be passed and agreed to. But the solution itself is not overly technically complex, but it does behoove you to have a technical partner, perhaps your internal IT staff or a preferred vendor, to take a look at everything to make sure that every I is dotted and every T is crossed, so the implementation can run as smoothly as possible. And as Sarah and Andy pointed out, there are other things you've got to be doing to your website, such as providing that toll-free number, easily identifiable email to be able to make sure to contact the appropriate people in compliance. So there's other things in your privacy policy as well. So all of these things working together are going to bring you up into compliance from a technology perspective. So I think that's it for our questions. I wanted to thank Sarah and Andy again for joining us today from Godfrey and Kahn. Before we close out the webinar today, I want to share two brief reminders. First, we really appreciate your feedback on our presentation. If you have a QR code reader on your phone, you can go ahead and scan the code that's on the screen right now to take our brief survey. And if you don't have a QR code reader, well, that's all right. You can go online at bit.ly/CCPA webinar to take the survey. And when we send out the webinar recording and slides in the next day or two, that email will also include a link to the survey. It only takes a minute or two to complete, and it's going to be really helpful for us so we know what's working and how we can make future webinars even better for you. And lastly, October is Manufacturing Month, and we have a series of free webinars and workshops scheduled throughout the month, all focused on helping manufacturers optimize their digital presence. October webinars are listed on the screen here, and more detail about them and our October workshops, along with registration, is available at learn@northwoods.com/octoberlearning. We'll hope you consider joining us for all, one, or just a few of these great events. So with that, thank you so much for joining us today. We hope you enjoyed the presentation, and we look forward to seeing you at a future webinar or workshop. Have a great day.